Good afternoon, members of the court. My name is Alex Whooley. I represent counsel on behalf of Jandis, the respondent to the arbitration proceedings. Opposing counsel for the claimant has made an unconscionable challenge regarding the appointment of the presiding arbitrator, Dr. Gagan. We therefore take this opportunity to address opposing counsel's flawed challenge. Having reviewed the specific grounds upon which the claimant's challenge is based, I shall shortly outline in our submission detailing why nothing therein, and pursuant to the governing LCIA arbitration rules effective of the 1st of October 14, or statute law, warrants the Council's removal of Dr. Gagan as presiding arbitrator. Whilst the arbitration clause of the contract does stipulate that the governing law shall be the substantive law of Scotland, it does not specify the Arbitration Scotland Act 2010. Accordingly, as the seat of arbitration is England, the governing statute is therefore Arbitration Act 1996, and in particular Section 24, in addition to the LCI arbitration rules that apply. Sources therefore comprise LCI arbitration rules effective 1st of October 2014, Articles 5, 10 and 16, Arbitration Act 1996, Sections 24.1 and Sections 24.2. Uncitral Model Law on International Commercial Arbitration 1985, National Statutes and Case Law. In order to assist the Court in delivering the appropriate determination, I would first wish to review the LCI arbitration rules before moving on to addressing the statutory application. From an arbitral context, parties must remember that party autonomy is one of the defining features of arbitration, with the inherent benefit that flexibility of arbitration procedures compared to court procedure and compared to court procedure, and arbitration's potential to be better acquainted with the specialist nature of the matter to hand. This can give rise to occasions whereby parties and appointees may be fleetingly acquainted. Such familiarization, as in the case of Laker Airways versus FLS Aerospace, was in itself inadequate to justify the LCIA court determining the removal of the presiding arbitrator. Possession of specialist knowledge by arbitrators could well increase the risk that the arbitrators themselves either has his own firm views on the subject, or has done business or is involved with disputes with one of the parties or the legal advisors. This was recognised in Russell Trading Limited versus Gill and Doofus in 2000, where I quote, It can be fairly assumed that on the reasons why the parties have agreed to trade arbitration is that they wish to have the dispute decided by people who are themselves active traders and so have direct knowledge of how the trade works. However, if the traders are themselves to be active traders, there is a likelihood that at least one of the members of the tribunal will at some point in time have commercial dealings with one or both of the parties. There are many features of commercial arbitration which find no parallel in the more formal procedures in courts. They are known and accepted by the parties, and many people number them among the advantages of arbitration. In the case of the trade tribunal, the fact that the arbitration has previously had commercial dealings with one or both of the parties has never been regarded as sufficient of itself to raise a dispute about the ability to act impartially. Opposing counsel's submission with reference to LinkedIn, fleeting acquaintances with my co-counsel, or indeed past unrelated case workload, is evidently immaterial and fails dramatically to satisfy Article 10.1, circumstance that give rise to justifiable doubt regarding Dr. Gagan's impartiality or independence, and reflects the Honourable Dr. Gagan's reasoning for not resigning the arbitrator role when opposing counsel attempted to raise a challenge. This challenge reflects nothing more than a tactical ploy on the part of the claimant's counsel, and Dr. Gagan had every reason to reject it and not avail of Article 10.4, given this effectively challenges Dr. Gagan's integrity. Indeed, the challenge itself to the presiding arbitrator not only asserts justifiable doubt, but effectively raises a challenge of bias on Dr. Gagan's part. As already outlined, nothing in the opposing counsel submission in any way satisfies the required burden of proof, and as such should be dismissed. Furthermore, the submission of the written statement detailing the grounds of Article 10.1 challenge failed to conform with the 14-day stipulation under Article 10.3 post-formation of the arbitration tribunal. It is a matter of record the tribunal, having formed on the 17th of September 2015, held its first hearing on the 1st of February 2016, over 4 months post-formation. Just how long does the claimant parties require before it raised this issue? Thereafter, none of the grounds outlined in the claimant were unknown to the claimant. It cannot logically argue that it only now, for the first time, has become aware of the issue regarding the parent company, Carney Things, or indeed the public forum information regarding LinkedIn acquaintances. Therefore, the opposing counsel has raised this challenge too late, and purely on adherence to the procedural rules, the challenge must now be dismissed. Statute application. In England, the uncritical model law has been adopted in its entirety. The Arbitration Act 1996 differs from model law in that it does not contain a separate requirement for independence over and above impartiality. Section 24(1) in particular applies to court, where applicable to court for arbitrator removal. Outlines A. The circumstances exist that give rise to justifiable doubts as to the impartiality and the substantial injustice has or will be caused to the applicant. The Arbitration Act therefore accepts that the lack of independence, unless it gives rise to justifiable doubts about impartiality, is not relevant. The mere fact that the presiding arbitrator is known to the respondent counsel in no way justifies the claimant's challenge to the Honourable Dr. Gagan impartiality and capacity to preside the arbitration. Counsel for the claimant has failed to establish that any of the 5 possible grounds contemplated under Section 24 of the Act are applicable. What's more, to allege a substantial injustice may cause as a result of Dr. Gagan's conduct, which as established was merely doing his daily job, is accusatory and ill-conceived on the part of the opposing counsel. The test for impartiality was summarised best by Lord Hope in Porter v. McGill at paragraph 103, where I quote, "Whether the fair-minded or informed observer having considered the facts would conclude that there was a real possibility that the tribunal was biased." Again, I would contend that nothing outlined in the statement or in oral hearings heard today satisfy the outlined test or stipulate real reasons for the removal of Dr. Gagan. Lack of confidence in the arbitrator on the claimant's part is insufficient to form the sole basis of a Section 24 application. Similarly, as outlined in Ilaker Airways v. FLS Aerospace Limited in 1999, risk of familiarity, as purported by the claimant in this case, is also insufficient and should be dismissed accordingly. My co-counsel opinion of Dr. Gagan's past work on unrelated case is in itself of no consequence to Dr. Gagan, nor can it be in any way taken that Dr. Gagan would therefore conduct himself in an unprofessional manner for the task at hand. To insinuate as such reflects a poor consideration of the opposing counsel, but should not cast slight on the integrity of Dr. Gagan. Challenges to the arbitrator's independence or impartiality are rare, with successful challenge even more so. LCIA court decisions on arbitrator challenges between 1996 and 2010, as outlined in the Arbitration International Volume 27, Number 3, 2011, identifies only 6 such cases as contained to the 28 published abstracts, with only 3 number involving relationship conflicts deemed to satisfy the justifiable doubts criteria. Of particular relevance to the case in hand is when compared to LCIA Ref number UN 3476, where the court rejected a challenge based on the arbitrator's own prior work as counsel to the respondent on an unrelated matter. The LCIA found that the past relationship did not give rise to any doubts as to the arbitrator's impartiality. A similar ruling, given the similarity of Dr. Gagan's case, must now also be sustained. The requirement that an arbitrator be independent and or impartial is a fundamental one, which goes to the heart of proper adjudication of disputes. Nothing purported by opposing counsel has in any way satisfied the LCIA rules, in particular Article 10, revocation and challenges. There is no justifiable doubts as to the suitability of Dr. Gagan, and none that he in any way had to declare previously. Further, based purely on the late submission of the challenge, even after the first hearing had already been conducted, and pursuant to Article 10.3 and the 14-day rule therein, the challenge should be dismissed. What's more, notwithstanding no justifiable doubts as contemplated pursuant to Section 24(1), the power of the court remains a reserved one, as made clear by section 20.4. As the LCIA rules govern that there is no case to be had, referral to Arbitration Act 1996, section 24.1 is also therefore defeated. Accordingly, the respondent respectfully requests the LCIA court to dismiss the claimant's challenge, given the clear opportunistic exercise it was made to avail of some tactical advantage to remove Dr. Gagan, whose integrity on the part of the respondent is beyond repute. The respondent looks forward to the recommencement of the arbitration proceedings, with Dr. Gagan's presence as the presiding arbitrator therein. That concludes my submission. If there is no further questions, I wish to thank you for your time. Thank you.